So welcome back to Law News. We just listened to the opening statements there from the prosecution, short and to the point, as I said before. We have on the line now Vincent Hill, who is a former police officer and host of the Beyond the Badge podcast. Vincent, good to see you here on the Law News Network.
Aaron, thanks for having me on. I appreciate it.
Yeah, so we've got an interesting case here, and one that resulted in a flurry of activity from the law enforcement perspective, because this was, by all accounts, a pretty crazy scene. You got a relatively small police department on Cape Cod, called out in the middle of the night in February, which is the coldest month of the year in the cold climates, and they're out there in 10-degree weather trying to dig through the snow for these improvised bombs that they don't know whether they're real or they're fake. You got a boom box with a flash bang, a smoke canister, witnesses hearing heavy metal and symphony music while there are people getting gunned down in a neighborhood. And I say truth is stranger than fiction. This is one of those cases. So from a law enforcement officer's perspective, if you were working this scene, if you were unfortunate enough to get called out at this in the middle of the night, where do you start?
Yeah, Aaron, like you said, this sounds more like a video game or a movie. Unfortunately, it wasn't. It was very tragic. And you're dealing with weather where, of course, you're going to miss crucial evidence when you're trying to get through snow and through ice. And dealing with the cold, of course, people don't realize when you're in 10-degree weather, you don't function the same way you would in, say, 85, 70-degree weather. So there's a lot that these officers had to do to process this scene. I'm sure it was a very meticulous process to get through these devices, and they had to do it very meticulously, of course, because we're dealing with what they thought was at the time explosive devices. So it was a very slow process, and the cold probably slowed it down by about 30%.
One thing that I was impressed by in the testimony we saw today is that we've got a neighbor who saw this vehicle engulfed in flames, things that he described as fireworks going off that could have been one of a number of things. And sometimes when cars catch fire, the tires pop due to the heat. People think that that's an explosion. It's really not. It's just the tires blowing up. Could be automotive fuels catching fire as the fire moves throughout the engine compartment or into the gas tank, which is the worst case scenario. Okay, you've got that going on, but the witness calls 911 immediately, and then he starts recording it. Okay, we didn't see the videos because they had the monitor angled so that we couldn't see them, but the jury did. So I was impressed that we've got a lay witness on the stand very quickly, recognizing that something is very, very wrong in his neighborhood, and bam, he's gathering evidence. Is that the kind of witness that you like to see when you rolled up to a scene?
Oh, yeah, absolutely. As an investigator or just the very first responding officer, you want those types of witnesses. You know, one thing about eyewitnesses, they're not always reliable, but when you have video evidence, you cannot dispute video evidence. So that witness was very key in making this case.
Not only that, but he went back home once he heard gunshots, shut the lights off, locked himself in a room, called 911 again and said, okay, this has just changed. It's not just a vehicle on fire. That call was, if I'm understanding the timeline of events properly, enough presumably for dispatch to warn the responding officers, hey, this is not just a vehicle fire on a street in an apartment or condominium complex or a home neighborhood. This is something much more dangerous. So they knew going in that this was going to be a mess. Again, forewarned is forearmed.
Yeah, absolutely. I mean, anytime officers could get a jump on what could be a possible ambush going into a scene like that, it's always a plus. And I think that was very beneficial in saving a lot of officers' lives, even though there was a shootout between the suspect and police. I think just knowing ahead of time that what was going on was a big deal.
How do police officers process this stuff, not just from a legal standpoint? We know they collect evidence. We know that they have to oftentimes record very gruesome scenes. But, you know, when you wrap these things up, either at the end of the day, the end of the night, whenever, and you go home and you stop and say to yourself, well, you know, I had my gun, I had my badge, I had my uniform, but what the heck did I just see today? Do those moments go through your mind, or do you just try to unplug from it all and say, I'm going to enjoy normalcy for a little while?
Well, yeah, absolutely. They go through your mind. I mean, there was a lot of stuff when I came home I couldn't go and tell my wife. It was just some of the most gruesome stuff you would see that no one should really have to see. So you kind of have to just compartmentalize that stuff, find an outlet to deal with it. For me, it was working out. For other officers, it's something else, a hobby. So you just have to be able to put that to the side, realize it's a job, and not let it affect you. But it's very difficult. A lot of officers will get PTSD. They will suffer from depression. You will see suicide rates based on what officers see in the field.
As though where any sane individual, regardless of where they were in observing it, was probably looking at this saying, what the heck just happened?
Yeah, I mean, this is probably one of the strangest murder cases I've ever heard of. I mean, you have fake bombs, you have a car on fire, you have a shootout with police, you have a manifesto, you have the suspect strapping a camera to his chest to record it on video. I mean, it's probably one of the strangest cases I've heard, and I'm sure one of the strangest cases those officers have ever dealt with.
I mean, one of the allegations here is that you've got a Coast Guard member who drives up from Virginia to go kill this other Coast Guard member and to injure her wife, and then winds up shooting a responding officer in the process. You know, we're getting some of the evidence in here. We've got this boom box with these canisters attached to it, these fake bombs and everything, and they're being described as law enforcement grade implements, or that they contained law enforcement grade parts. So I'm guessing there probably was a bit of a sense of bewilderment. See, like, how does the average person get a hold of this? What's this guy's background? You know, how do we deal with this?
Yeah, unfortunately, Aaron, a lot of those items you can get at your local Army surplus store or your police fire store, right? There's nothing that says civilians cannot go in there and purchase items. And quite frankly, a lot of stuff, unfortunately, you can order via the dark web. Which is very, very popular for criminals. They order firearms there. You can order narcotics on the dark web. So it's not clear where he got those items, but what is clear, it's very easy to get a hold of those items.
I guess I've been shopping at Target most of my life, or wherever. I wouldn't know where to find this stuff. You know, how do you think, we don't know a lot because this is the first day of the case, but from what you know thus far, do you think the investigation played out about as well as it could from a textbook circumstance, or do you think there's more that should have been done, at least from a police officer standpoint?
No, I think it played out pretty well. Of course, the defense is going to, and they already have, say he didn't know what he was doing. He didn't realize what he was doing. But as a prosecutor, what I would say is, at what point do we say, hey, we don't know what we're doing? You wrote this 250-page manifesto. You drove to this person's house. You didn't live right down the street, right? You set your car on fire to slow down police. So there was a lot of thought that went into exactly what he did. So I think on the defense side, it's going to be hard to prove, well, he really didn't know what he was doing, because a lot of that stuff was premeditated.
Oh, I agree. I mean, some of the defense arguments here just seem to me that they're attempting to mount about the only thing they can, because in this case, the facts really aren't in dispute, okay? The guy gets caught red-handed at the scene. He surrenders, okay? It's not a secret what he's been up to. He's got the manifesto. He's got this deer camera strapped to the tree outside the home shared by these poor women. Okay, it's pretty well known who did what and when. We've got the phone recordings, we've got the evidence, we've got the purported bombs that were investigated. We've got all this stuff. It points to the same person. It's not a whodunit. We know who did it. The person who did it wrote the manifesto and basically proffered an admission. I guess the only thing that can happen is that the defense can try to pull this mental health thing, and that's just a question of psychiatric evaluation more so than immediate law enforcement evaluation, and it changes the punishment depending on the state. So again, I have to assign myself homework every evening. My next one is to read the Massachusetts laws on what's going on with mental health offenses, because in some states, and I'm guessing Massachusetts is probably similar, it doesn't result in a lesser penalty. It's just a question of where you serve it. Do you serve it in a psychiatric institute, or do you serve that time in a regular prison? You know, assuming that there's a conviction, which in this case I would venture to bet that that's kind of where we are.
Yeah, I think that's coming.
Yeah, the whole defense tactic of just turning around and saying, well, he might have had high functioning autism or Asperger's or something. And it's just kind of like, where is that coming from? And then trying to attack the person who was supposed to evaluate his mental health for not doing a proper examination. Okay, well, that's slicing and dicing this issue almost too thin for my comfort, because again, it's a question of, okay, who done it? And we know
Right.
what was done. It was planned with a specific purpose. You got about a dozen different charges in 30 separate counts. And I know that the last charge was re-alleged 10 separate times for the number of devices that he had on him. This is throwing the book at the guy, and it's a highly choreographed situation.
Absolutely, and I think the autism defense is, quite frankly, in my opinion, ridiculous. I mean, here's a member of the U.S. military, the Coast Guard, Army veteran, an Army veteran. I assure you that had he had autism, A, he likely wouldn't have entered into the Coast Guard, and B, they would have found it a long time ago. It wouldn't just be because he went out and killed 2 people. There would have been symptoms, there would have been signs, there would have been evaluations from his commanding officers. All of those things that would have occurred should have occurred if that is their defense.
Yeah, I mean, I'm wondering what's going on with that. Are we going to see that evidence here, or are we not going to? I can't picture, off the top of my head at least, a scenario where the prosecution calls the Coast Guard commanders and says, was this guy normal? Because it starts to edge a little uncomfortably towards character evidence, which as a general rule is inadmissible. But there's the old rule also that if you put your health or mental state into play, then the other side can cross-examine you about it.
Yeah, and to your point, you're absolutely right. But then if we start wanting to call the Coast Guard and wanting to get records, there's a whole nother legal aspect to that. You can't just call up a military base and say, hey, tell me about this individual, tell me about this soldier. Even though he's in a court of law, in the civilian side, there's some military and civilian cross-checking that needs to be done before you can even get that information.
Yeah, I'm really wondering if I should check with my friends in the JAG program and just see what that procedure is, because it's an area of law that I will admit I know nothing about. There are areas that I have not studied, and this would be one of them, is the interplay between that. It sounds to me like overall, though, this was a thorough investigation. The prosecution seems to have buttoned the argument up very, very cleanly, put it in a nice box, wrapped a bow around it. They gave the opening statement in probably about 10, 15 minutes. It's one of the fastest ones I think I've ever seen. I don't know about you.
Yeah, especially for something that happened, we're talking 2 years ago now. I thought the opening statements would have gone a little bit longer, but of course the prosecutor didn't see it necessary to make it go a little longer. But I think if I was a prosecutor, I would have had just a little bit longer opening statement and really driven home some key points of the case.
Well, again, though, part of I disagree with you a little bit there, because I think that the case is almost shocking enough on its face where, sometimes less is more. Hey, ladies and gentlemen, the evidence is going to show you this is what happened. Back away and you stew on it. I mean, I think that it's shocking enough where the jury's just sitting there saying, gosh, I mean, this is pretty bad. I think I understand it right off the bat. He wrote this manifesto, drove up, planted the fake bomb, set the car on fire, went into the house, shot and killed one woman, shot and injured her wife, then wound up shooting a responding officer and then surrendered, and then there you go. I mean, it's such a bizarre case that I think the facts just kind of stick.
Yeah, the facts definitely stick, and to your point, they definitely speak for themselves. I mean, it's definitely not rocket science. We're not talking OJ and Nicole here. I mean, it's pretty clear here what happened.
I actually want to take a little pause here on our conversation. Let's listen to the defense's opening arguments, because we played through the prosecution's again just before you came on. So I want to go and play that. It's the third clip that we pulled today. Let's listen to these a little bit so we can dissect them a little bit more.
Folks, good afternoon. spent a few days together. Once again, I'm Drew Segadelli, and I'm here on behalf of Adrian Loya. Being a part of what we did the last few days, you saw the pains we've taken in the impalement process. The theory behind that obviously is we want to seek you heard the judge use the impartial jurors. We likewise would like to believe that any preconceived bias or prejudice are essentially left at the courthouse steps. But we don't ask any jurors ever to set aside their common sense. Like Mr. Glennie, or his honor, told you about keeping the open mind, I will likewise do the same thing. But I will ask you throughout the trial to still utilize common sense and exercise that gained through life's experiences. Now, it's a challenging case. We're going to be applying the same principles of law and so forth as one would in a trespassing case or a capital case of this nature. But it is still challenging. And as we all know, utilizing common sense, and the judge will tell you eventually that the Commonwealth, and you've all heard this, bears that burden of proving the case. That proving the case beyond a reasonable doubt. And I'll just submit to you early because we're not arguing now, we're just hopefully helping you. But it is a significant burden. And you heard somewhat in the impeachment process that it isn't only proving beyond a reasonable doubt that that fellow did these terrible, tragic acts. It's not only that, but they also must prove beyond a reasonable doubt that at the time of this conduct, that he, as a result of mental disease or defect, did not appreciate the wrongfulness of his conduct, or that he could not conform his conduct to the requirements of law. I'll submit to you, some people use the expressions, who done it? Though this isn't the case, you're going to see an abundance of evidence, a great majority of which came from that fellow, my client, as he wrote a 265-page document about this plan, as he wrote letters to Lisa, some 23 pages before this event. You're going to hear that some of this plan, or this planned mission, could have gone as long as 16 months, the planning stages, that it was meticulously planned, meticulously detailed in each and every nature of it. Listen for that. Not only that, what he left in the paperwork, but when speaking with the police officers on 2 different occasions for hours. And you'll have the opportunity to hear that. And I'd ask you to pay particular attention, not only to the acts that occurred on his birthday, somewhat unusual, February the 5th, 2015, his 31st birthday, but the specific detail in the 265 pages, in the detailing it to the police, because I'm going to suggest to you that's all going to wind in to his disease of defect. That's not the legal label. It ultimately will be for you, but how do we go there? Now, keep in mind, as the judge has instructed you, the defendant doesn't have to do anything. Why is that? As the judge told you, he is presumed innocent. But I think the evidence is going to show you and lead you down a particular path. And we have witnesses, and I anticipate you'll hear from witnesses in this case. And some use the expression expert witness. That's really when you become the judges. It will be for you to determine whether or not you accept or exclude. They're not given any grace because they're termed this, or they have a particular profession that could help give credence to their opinions. But you'll hear from I anticipate you'll hear from a Dr. Daniel. Let me step back. Experts, as one who utilizes common sense could assume, they base their opinion on their database or the accumulation of all information they can utilize to draw their conclusions. Well, you'll hear from Dr. Daniel, you'll hear everything he utilized to form his opinion. Not only were there police reports and 265-page documents, and police reports speaking to collateral families, speaking to the Coast Guard in their investigation, speaking to the lawyers perhaps. He spent some 43 hours, the evidence will show you, with Mr. Loya. Some 43 hours. And he's going to suggest to you that he suffers from a significant mental disease or defect that both deprived him of the ability to conform his conduct to the requirements of law, and we go with that, what's called the McCool standard, appreciate wrongfulness, conform conduct. He's going to suggest to you, and that standard, ladies and gentlemen, is given to us in the alternative. So it's not and, it's appreciate wrongfulness or conform conduct to the requirements of law. Dr. Daniel, after spending all that time, you have the ability to praise him like us. You'll also hear from, and I'd submit to you, Dr. Daniel has a significant amount of experience, but you'll also hear from a Dr. Martin Kelly, who has a long history in testifying and so forth. You may hear such evidence that he has testified in some 300 to 400 cases. That he was originally hired. The court eventually asked him to speak to Mr. Loya, and he spent better than 9 hours with Mr. Loya. And pursuant to his training and experience, he's a psychiatrist. He said, somewhat of a different label, where Dr. Daniel gives some type of delusional label, but it's a significant mental disease or defect. Dr. Martin Kelly suggests that it's on the autism spectrum, in fact, perhaps a high-functioning Asperger's. And because of that, and likewise, he suffered from a delusional base on that particular day. We're focusing on that day, February 5th, because it's at the time the conduct is committed, that he could not, Dr. Kelly could not conform to the requirements of law because he's in a delusion. In fact, it was in his mind, Dr. Kelly, I believe the evidence will show, it was a good against evil scenario. You're going to hear what was occurring in his head in that particular day. That's why I said it's a challenge. This case is going to be a challenge. It's not the whodunit, but one has to look seriously at this testimony about what was going on. What was he doing in the planning stages? What caused him? What motivated him to do all this? And what was it as a result of? You're going to hear from there's a Dr. Holtzman, I believe, who works for the state, not wholly convinced of a mental disease or defect that would give or deprive somebody of the ability to conform their conduct. But what we'll also look to, and the evidence may show you that Dr. Holtzman didn't have that database I talked about, police reports. I don't think he had the ability to see Dr. Kelly and Dr. Daniels' reports. So one might suggest his foundation was not sound enough. Eventually hired years after this, and I would just submit to you at this time an opening statement. The most important time is the event sometime after 2 a.m. on February the 5th. In fact, the first call came into 911 at 2:11. Mr. Loya was taken into custody at 2:48, so there's roughly 36 minutes that's involved here that we're going to be looking at. I'm going to ask you to keep an eye on. But you're eventually going to hear, I believe the evidence is going to show you, you're going to hear from a Dr. Ida Shine, who was eventually hired to give an opinion. And she gave an opinion. Once again, I'd ask you to look at what type of database does she have. She had a period of better than 8 months to go and visit and see Mr. Loya. One would hope to assist her in her evaluation of him. She never took that opportunity. But in light of that, she'll suggest to you he could conform, or he doesn't meet the standard. When I again say that, I'd ask you to keep an open mind, as the judge will tell you. That's ultimately up to you. Those folks, even if they're labeled the experts, it's going to be up to you, ladies and gentlemen, to make that determination. And she never, Dr. Ardisha never availed herself of that. Again, the whodunit aspect, keep an eye on where it came from. The vast majority came from Mr. Loya, because it's part of that delusional base we're starting with. And I'll eventually ask you to look, when you deliberate, look at all of that evidence. to see that first aspect of that burden that Mr. Glennie has to carry from start to finish. Yeah, one can probably get over that first hurdle, but the second, at the time, and that's why it's such a challenge, at the time that he could conform himself, that he appreciated the wrongfulness, and I would submit to you at this stage that he could not. And after that challenge, one will submit that the Commonwealth could not get over that burden of proving the case beyond a reasonable doubt. Thank you.
Thank you, counsel. Surely. Jurors, anytime I go to the sidebar, you're welcome to stand and stretch if you wish. Just don't discuss them.
That was the defense's opening statement in this case we're covering now out of Barnstable, Massachusetts. It involves a Coast Guard member, Adrian Loya, who is accused of murdering a fellow Coast Guard member, injuring that member's wife, injuring a police officer. So, Vincent, we're listening to that yet again here, and you actually picked up on something that happened at some point that I didn't notice. Apparently, the defendant was standing at attention. What do you read into that?
Yeah, it's very disturbing. I mean, he's on trial for murder, and yet he's acting like the good soldier, right? I mean, at the onset, when he came into the courtroom and the judge entered and everyone stood, he was standing at attention with the straight edge statue, his fist cuffed to his side. That is standing at attention for all intents and purposes, as if he were in a military formation. So I don't know if that's just a ploy by the defense to make someone think he is not in the right mindset, but to be still playing the good soldier, or I don't know what the deal was with that, but I did find it very odd.
Yeah, I didn't pick up on that. I'm glad that you did, because I'll add it to my notes here of things to try to make sense of. And that list is already 3 pages long in this case. One other thing we were talking about a little bit before, and I'm curious to hear what you think about it, is in this courtroom, the witnesses have to stand up. I can't remember at any point seeing or being in a courtroom, watching a trial that involves the witnesses standing as they deliver testimony. Have you ever been in that kind of a situation?
Yeah, I've been to plenty of court proceedings, and I've never seen a witness have to stand to give testimony. The only thing I could surmise is maybe it's because of where the court is. Maybe they're keeping to some old tradition that was there in that courthouse. That's the only thing I can think of, but I personally have never witnessed that.
Yeah, I thought I would ask you, since your experiences in law enforcement here, when a police officer is testifying, what are some rules of thumb that a law enforcement officer needs to keep in mind?
Well, of course, the obvious, don't lie, of course, but that's a given. Anytime you're going to court, especially a case that's 2 years old, you want to go over your notes, because, of course, the defense is going to tear you apart. Anything that you said 2 years ago, you better make sure it matches when you testify in court. So it's always important to go over your notes, go over your reports, everything you wrote down, everything that you presented at the time to the grand jury, everything you presented at the initial preliminary hearing needs to match up. So go over your notes, make sure everything lines up, because the defense will make it look like you're trying to either hide something or tell a lie.
And I also oftentimes see police officers sort of angling themselves toward the jury a little bit. Is that something that you wind up getting coached to do, or is it just sort of a natural reaction? Because obviously when you're on direct examination, you want to speak to the jury. But oftentimes I see attorneys not lining themselves up in such a way that would really allow a police officer to speak to the jury, which I was always told never to do. I was always told to sort of stand almost behind the jury, so that if I'm a prosecutor, then I have an officer sort of speaking through the jury and at the jury to get to me to answer my questions. But what do we make of the sort of general body posture in the speaking directly to the jury?
Well, it's not something that's really taught or coached. I think what it is, police, we're face to face, right? We always want to see who we're talking to. We never want to talk to someone on the side of us, definitely not behind us. It's just a natural instinct for police to want to face their audience. So you will see a lot of police officers, if not all, usually face the jury when they're giving their testimony.
That's sort of an interesting perspective on things. You know, when it comes to scheduling and everything, how does this work on the inside? You're back and forth between patrol and court. What does that really look like from the perspective of somebody who's, you know, lived inside that system?
Oh, it looks very tiring. I mean, think of those officers that were out the night this happened. We're talking 1:30, 2 o'clock in the morning. And let's say they process that crime scene, but yet they still have to go to court for another case, right? So you've been working all night, then you still have to go to court the next morning for another case. And you may sit in court for 5 minutes, you may sit there for 5 hours. So I don't think a lot of people realize that even though you may have closed the case, you may have written your report and turned it into your sergeant, your day is still going even if you're technically off duty.
So that's interesting. There's in some departments, I assume that there was a lot of scheduling leeway for this, but I'm hearing from you that there might not be.
Yeah, at least not in the department I was with, Nashville Police. I mean, if you were assigned for court the next morning, you were in court, and I believe it's that way for most, if not all, departments. If you have court, you will be at court, whether you were working the previous day or not. Now, there may be some departments that have a set schedule. You will see that in a lot of smaller departments. I will add that they have set court dates, but when you're in a big municipality, a big city, you don't actually have that luxury because your docket is just so huge that you have to move those cases out.
Wow, so it sounds like juggling a lot of stuff for sure.
Absolutely.
Now, a couple of other things, and I know I'm just asking questions that I haven't had a chance to ask any of our other guests because I think you're the first actual law enforcement person that we've had here on LawNewz. But why is it that we see some officers testifying in a suit and tie and some wearing uniform? Is there any protocol on that, or is that something that's arranged with the prosecutor's office, or is it just at officer's discretion?
Yeah, I would say it's officer discretion. I mean, me personally, I always would go to court just like you see me now, even when I was in patrol before I went to narcotics. I did it for a few reasons. A, when you're in uniform, you get a lot of people approach you to ask you questions, law enforcement questions. And I'll be honest, when you've worked all night and then you're at court, you know, the last thing you want is a bunch of people bombarding you. But on the flip side, when I would wear a suit, people would think I was an attorney and want to ask those questions. But I always wanted to distinguish myself. And plus, me personally, I think it gives a better look when you're in a suit and tie. You look very, very professional, and you look like you're about your business.
Well, let's take another brief pause here and listen to the first witness who was on the stand here. This was a law enforcement officer who was one of the first responding officers to the scene.
Loud voice. Could you state your name and could you spell your last name?
My name is Joshua Parsons, Parsons.
And how are you employed, sir?
I'm a police officer with the Bourne Police Department.
And how long have you served with the Bourne Police Department?
Roughly 5 years.
Now, drawing your attention to the date of February 5th of 2015, were you on duty on that date?
Yes, I was.
And what duty were you assigned?
I was assigned to patrol the Pleasant Space Center for Bourne.
And how were you dressed when you went for to do that shift?
I was dressed in our blue duty uniform, badge, gun belt.
And did you have a car, or were you with somebody else?
I was alone in a marked cruiser.
All right. Now, drawing your attention to at or around 2:12 in the morning, did something take place or happen?
Around 2:12, I was dispatched to Roundhouse Road for a reported car fire and a second report of gunshot victims at number 11 Roundhouse.
What did you do after receiving that call?
Drove to the scene and arrived with several other officers. And as soon as I arrived on scene, I saw a burning sedan parked perpendicular with the road, made it impassable for any vehicles or pedestrians.
Now, when you say burning vehicle, could you be any more specific?
The vehicle was fully involved. Windows were all blown out, tires were flat.
Okay, so
Burning as you could get without being totally burned out.
it wasn't a minor fire. This was a totally engulfed car.
Fully involved, yes.
Now, you said that you were a police officer for 5 years up to today.
Yes, sir.
And would that Roundhouse Road area be part of your patrol at times, being a police officer in Bourne?
Yes, it is.
If I might approach, please, Aaron?
Please.
If you'd be kind enough to look at these two photos and just refer to what's marked as A, do you recognize what that is?
Yes, I do.
And what is that?
That is the Roundhouse Road condominium complex.
And that's taken from the air, of course.
Yes, it is.
In photo B, is that just the same area from a different angle?
Yes, it's from a different angle.
And would this be consistent with what the weather conditions were at that time?
Yes, very snowy.
You know how to offer this?
Offered.
Okay.
Exhibit 1.
May I publish it to the jurors? So that-
Well, you can show it to them. Well, let my clerk mark it. Jurors, anything that's marked as an exhibit, you're going to have in the jury room during your deliberations to examine to your heart's content. So if you just get a quick look at it in the courtroom, don't worry, you'll have it to look at as long as you want.
So now, when you just indicated that you came into the complex and there was a burning vehicle, could you point on the map as to where that would have been located?
You're blocking some of the jurors.
All right.
Yeah, you will.
The vehicle would have been parked approximately right here across the road, right near the bed.
Okay. And if you could just show that would be in photo B.
Be right over here.
And as these photographs show, that roundhouse complex, how many ways were there to get into it?
It's only single access. There's one road in.
And that car was blocking that access in egress?
Yes, it was.
So you drove with your cruiser to that area, and what happened?
Parked approximately about 100 feet back from the fire. There were several other vehicles there already from my department as well as fire department. Walked up near the vehicle with other officers. Immediately noticed that there was a object in the snowbank to the right near a fire hydrant. It appeared to be an IED of some sort.
Okay, what do you mean by IED?
Some sort of improvised explosive device placed in the snowbank near the hydrant. Looked like a couple of soda bottles filled with small items and then had wires on it.
Okay. If you be kind enough to look at this, where do you recognize?
That was the,
In photograph, that's what you saw when you were, right?
yes, it is.
Assistant marker ID is pretty much.
Mark for identification.
That will be identification of the,
Jurors, when something's marked for identification, that's how we keep track of it in the stenographic record. Maybe it'll become an exhibit, maybe it won't. We'll have to wait and see.
In any event, exhibit, I'm sorry, item B, here, that's a very accurate depiction of how that looks, is that correct?
Yes, it is.
So I move to offer B at this point as an exhibit, even on this until the whole thing is in through the ways.
Then it remains for identification if you're not going to single it up. And frankly, if it's not in the exhibit, you turn it around so the jurors aren't viewing it. The jurors see what's an exhibit, not what's being marked for identification, until it matures, if it does, into an exhibit.
Okay, welcome back to Law News, everybody. We're here with Vincent Hill, former police officer, current host of the podcast Beyond the Badge. And we just heard that chastisement from the judge for the attorneys to follow really formal evidence introduction techniques. We've talked about that quite a bit here. Vincent, wanted to ask you a little bit about the overall setting of this trial. We've got a smaller community. The jury was seated pretty quickly. They, went through about half of the jurors yesterday, seated a few more, I think, this morning, and they went off and running pretty quickly. Is there anything we can read into that?
Well, I think, of course, when you're dealing with a much smaller area as opposed to, say, Los Angeles, you don't have a huge population to pull jurors from. And you can assume that most of these jurors, this case was 2 years ago, they either have forgotten about it or, quite frankly, may not have heard about it. They may have recently moved into the area. Some people that were there at the time may have moved out of the area. So I think it was probably around the right time frame to have selected a jury.
That would make sense to me as well. I know we talked a little bit off camera about it. It's a transient area. You're right on the neck of Cape Cod, a lot of tourists coming and going. The first lay witness is a manager of a hotel of some fashion, and not a surprising occupation for somebody who's a year-long resident who might be registered to vote in that jurisdiction and therefore be called for jury duty in that jurisdiction. So that's not a big surprise. What also popped up on my radar screen from a law enforcement perspective in this case is the cooperation from neighboring departments. Barnstable's not a huge community, and one of the first witnesses from law enforcement, I think it was the very witness we just saw, said that when the defendant was read as Miranda, there already were state police coming in, and there already were officers from one of the neighboring departments to the southwest. Yeah, how does a smaller department deal with something that's this big when, and I'm just taking a guess here, but knowing what I know about Cape Cod, probably the only thing this department usually deals with are incidents involving vandalism in tourist locations and narcotics. That's sort of the bread and butter for a rural department or a department in a smaller community. How does a small department all of a sudden deal with something this big?
Well, quite frankly, they don't. I mean, they usually, when you're dealing with smaller departments, they don't have, say, homicide detectives or robbery detectives or sex crimes detectives. They may have one person that is a general detective that is, responsible for investigating all of these crimes. And when you're talking about one dead person, you're talking about one critically injured person, you're talking about bombs and car fires, they're not equipped or trained, quite frankly, to deal with this. So that's why you saw the state police and neighboring counties come in to assist in the investigation. And it's not really that uncommon when you're dealing with these smaller departments to see that, because quite frankly, they're just not equipped for it. They don't have the right training. A lot of times they may not even have the right equipment to deal with these situations. So you'll see that quite a bit.
Now, I just did pull the data on the jury breakdown here. There are 9 women and 6 men, and I know a lot of people are always trying to count to certain numbers here to try to figure things out. This presumably being the number before we pull out alternates. But is there anything to be said from looking into the crystal ball in your perspective about what that breakdown might mean?
Well, anytime you have 9 women versus 6 men, I mean, look at the victim who died. She was a female. She was killed by someone that obviously was stalking her, that was obsessed with her. So I think we can say, yes, be impartial, look at the evidence, but you're going to be dealing with emotions here when you're talking about some of these jurors. And I'm sure, not to say that the females would be the only ones to react that way. I'm sure there's some males that would do that as well. So it's going to be very important that people look at the evidence, look at the crime itself, and make a decision based on that.
Yeah, I mean, I agree with you. Here's the thing. I mean, I'm a guy, and just this whole thing just starts out with the creepy buzzer screaming in my head. The deer camera in a tree to look in the windows of the house. I mean, you know, the manifesto, just the facts on the table here, just like, you know, if I knew a guy who was doing that, I'd be like, dude, there's something wrong with you. You know, like I might need to report this. It cringes me too, and you know, if we have 6 reasonable men on the jury, I think it would creep them out just as much as it would creep out the 9 women.
Yeah, absolutely. I don't think there's a person on that jury that's not already thinking this guy is off. Like there's something wrong with him to do what he did, to plan it out this long and to go through the steps he went through. So yes, absolutely, the male jurors are creeped out about this and looking at what really happened. Yeah, absolutely.
Oh, Vincent, I want to take a minute here as we wrap the day up. Tell me about your podcast.
My podcast, Beyond the Badge, which is on radioinfluence.com. I actually talk about police issues that we see in mainstream media daily, but I talk about it from a perspective that most people don't hear, from a law enforcement perspective, someone that's actually been in the streets, who's actually done the job of policing, who knows things like use of force continuum, where someone who doesn't know that may say, hey, this was excessive force or this was unjustified, where someone that has done this job can talk to someone very layman terms and explain, okay, this is why a reasonable officer would have acted this way or reacted this way. Now, let's be clear. I don't justify everything that police do by any means on my show. I've called out certain police officers that have done certain things that were either unethical or illegal, but I give listeners a chance to hear it from a law enforcement point of view instead of a 2-minute package on mainstream media.
Yeah, you know, as a former reporter, I did the best I could to cram everything into a short story, but as even Walter Cronkite used to say, if people are interested in what they hear on the news, they should go consult a more expert source. The hope is always that that would happen, so you're the source making yourself available. And okay, I will give you credit for calling out your own profession. I do it all the time if I don't like what somebody's doing. So that tells me that you are a reasonable man.
Absolutely, I appreciate that.
So just to let everybody know where things are going, we are planning to cover this case again tomorrow, the Loya trial, Adrian Loya case out of Barnstable. They're planning to start at 9 o'clock, and they are taking about a 2-hour lunch break between 11 and 1 o'clock here on the East Coast, so a long lunch for analysis, and they'll be wrapping up at about 4 o'clock every day. So that's where things are going tomorrow. Vincent Hill, glad to have you on LawNewz. We appreciate you sticking around with us for the full hour here.
Yes, sir, Aaron. Thank you. I appreciate you so much.
Okay, we'll see you again.